presentations from Strathaven Airfield in relation to light aircraft safety and forestry planting at the site of proposed access at Munnock. Furthermore, there's an opportunity to review procedures in relation to other aviation concerns and agree processes for addressing other topics put on hold for now, including shadow flicker. Now, there are a few housekeeping matters before we proceed. Please note that as per the initial pre-examination meeting, this meeting is being filmed for live and subsequent broadcast via the DPA's website and YouTube site. By participating, you're consenting to being filmed and to the use and storage of images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Any information presented by you, in addition to forming part of a record, will be held as a historical record. It will also be held in conjunction with any DPA training. Thereafter, the information will be held as a historical record. Now, are there any questions from anyone regarding filming of this meeting? No, and just by a show of hands, are you all in agreement to being filmed today?
Alistair, before you proceed, will we be showing the films or will it just be kept by yourselves?
Is that yourself, Mr. Thompson?
Yes, Henry Thompson speaking.
Yeah, no, it's a public record, Mr. Thompson. So it's currently being live streamed on YouTube, and then it will be saved and available for anyone to view back in the future.
I don't try to avoid YouTube as much as I can.
Sure, but you're content to being filmed in that recording of yourself being available?
I'd like to think about it because you haven't put this to me prior to this meeting.
Well, if you don't wish to, I mean, you can turn your camera off if you like between proceedings. Okay, excellent. Right, in terms of using the microphones, if you're not speaking, make sure that you're on mute. If you are speaking, obviously unmute, and then remember to remute yourself after you've spoken. We're not together today, so if you could please familiarize yourself with any exits should there be a fire alarm in your location. Now, does everybody have a copy of today's agenda for the meeting? Yes, if not, there are copies available on the DPA website under the case reference WIN-310-1. Okay, now I'll ask everybody to introduce themselves. There's quite a few parties here today, so it'll take me a moment just to jot down who's here. But firstly, I'll start with the applicant.
Thanks, sir. Good afternoon. My name is Marcus Trinick. I'm a solicitor at King's Counsel, instructed by Craig Welton of Shepherd and Wedderburn, who's with me in the room. Also in the room are Claire Dowse, Head of Operations UK for Galileo, Laura Petrie, Senior Project Manager, and Colin Laverty of Pegasus, Planning Consultant. Thanks, sir.
That's super. Thank you very much, Mr. Trinick. North Ayrshire Council.
Good afternoon, Mr. Edwards and all. My name is Alan Finlayson. I'm North Ayrshire Council's Chief Planning Officer, and I'm joined today by my colleague Ian Davis.
Thank you. Now we'll work our way around the rest of the interested parties, residents and community interests. So I'll start with Glasgow Airport.
Yes, good afternoon, sir. My name's Stephen Blaine from Pinsent Mason Solicitors. I appeared on behalf of the airport at the previous pre-inquiry meeting, and as at that meeting, Christine MacDonald, who is the airport safeguarding manager, is also in this Teams chat.
Is Lisa Cameron joining us today?
She isn't at the moment, and so if she is able to join later, I think she'll be joining on the live stream as opposed to through this method, sir.
Thank you. And then Nat Safeguarding.
Excellent. Alistair Ault, I'm here representing Nat Safeguarding.
Brilliant, thank you. And then Fairley Community Council.
That's me, Rita Holmes, representing Fairley Community Council.
And is Mr. Grosvenor here as well?
Yes, Mr. Edwards, Melvin Grosvenor.
Thank you very much. And is Jackie Pearson with us for the Community Council?
Jackie, I think, sent apologies prior to this. He'll be at the actual meetings when they take place for the public inquiry, but Jackie can't be at the meeting today.
Okay, no problem. And then for West Kilbride Community Council, I'm not sure if anybody's on the call. I think someone was observing the call rather than being live. But is there anyone here from West Kilbride?
I'm Henry Thompson is from West Kilbride, but the council at the moment is they've just been put up for election. So we're waiting for the results from that.
Okay. Thank you, Mr. Thompson. CWP Energy.
Hi, good afternoon. I'm Kirsty Kelshaw, Legal Director for CWP Energy, and I've got my colleague Rob Fryer with me.
Excellent, thank you very much. Friends of Clyde Mearshall Regional Park.
Well, I'm Liz Parsons and I'm representing the Friends group.
Brilliant. Is Mr. Greenlands here as well?
I think he is going to join. He was out sowing wildflower seed and I don't know if he's back in time, but he may join at some point.
Thank you. Right, now, is there anyone here from Strathaven Airfield?
Yes, my name's Colin McKinnon and I'm representing from Strathaven Airfield, representing the British Mike Light Aircraft Association and the Light Aircraft Association.
Thank you, Mr. McKinnon. Now, just moving on to individuals that are involved. Do we have Mr. Duckett?
Yes, I'm here. Thank you. I'm a resident at Monarch.
Brilliant. Thank you. Erica Gold?
Yes, I'm here. Another resident from Monarch.
Excellent. Mr. Lesperance? Nope. Okay. Jackie Pearson. Oh, we've already spoken about that. Mr. Riddle.
Good afternoon, sir. Resident Fairley.
Excellent, thank you. And Mr. Thompson, we've already heard from yourself. Is there any other person that wishes to take part in proceedings today that I haven't checked off? Yes, Mr. Watson. Oh, sorry. I'll go to Mr. Watson, then come to yourself, Ms. McGregor.
Yeah, Andy Watson. I'm from Dalry Community Council, representing them.
Okay. Excellent. Thank you, Mr. Watson. And Ms. McGregor?
Good afternoon, sir. My name is Fiona McGregor and I am a solicitor with Dentons. I'm here today on behalf of Glasgow Prestwick Airport. I'm joined also by Steve Thompson, who's the Head of Assurance at Glasgow Prestwick Airport. We weren't able to attend the last preliminary meeting, but we are here today.
Brilliant. Sorry, could you just clarify your colleague's name again for me?
Steve Thompson.
Steve Thompson, excellent. Brilliant, thank you. Right, we'll move on to item 3 in the agenda. So parties previously agreed to adopt the code of practice and allow for, which would allow for discussion and agreement of procedures, with the ultimate decision on procedures lying with myself. Since the initial PEM, the Planning and Infrastructure Act 2025 has been given royal assent, with its provision making changes to the Electricity Act 1989 as applied in Scotland. One such change is the move from an inquiry process to that of a reporter-led examination. However, for the purposes of this application, we will continue to adopt the code of practice as it stands and come to an agreement after discussion on what processes are necessary for each matter. Is that agreeable by everybody? Mr. Trinick? Yeah. Any dissent? No, that's super, thank you. Now, moving on to additional information. I assume now that the applicant is proceeding with producing additional environmental information in the form of an updated noise impact assessment. Is that correct, Mr. Trinick?
Fighting with the microphone. Yes, that is correct. The noise additional information will be ready for publication on 6th March. I think I may have covered this at the first pre-examination meeting or in emails, but in case not, I request a direction under Regulation 20 that this information is required for the purposes of the inquiry.
Okay, Mr. Trinick, just to clarify, you would like, in effect, myself to request the information as an update?
That's correct, sir.
Okay. Okay, thank you. Mr. Watson, is it? You've got your hand up, and then I'll come to Mr. Thompson.
Sorry, it's Gordon to put my hand up there. If it's okay. Yes. I wanted to clarify something about noise that I haven't seen in any of the documents.
Yes, go ahead.
Is the noise activity actually going to be involved the noise that's going to come from the BESS as well?
Well, I think at the previous pre-examination meeting, we agreed to have an inquiry session on noise and vibration. I'll just double check my notes.
Yeah, apologies if I missed something in the process.
No. You weren't listed as an invited party to that particular inquiry, but I think you were going to participate in the community hearing session where that matter could be raised.
Okay, that's fine, just so long as it's part of the noise issue, yeah?
Yeah, I think it's worth highlighting to the applicant as well, if they're looking at the noise issue anyway, that they'll also look at the issue of any noise from the BESS.
It's just that, it's very close to our houses.
Okay. Thank you. Mr. Thompson?
The regulation that Marcus referred to, I take it as part of the inquiry process, but I take it too that the noise would have to comply with the Health and Safety at Work Act.
Well, yes, I think any legislative requirements or British standards would have to be adhered to. In terms of your question about Regulation 20, yes, that's part of the EIA Electricity Works regulations, which means that if ministers request additional environmental information during an inquiry, then it goes through a separate process in terms of advertising consultation. So in terms of your own involvement with it, nothing will really change. It's just a procedural issue in the way that it's advertised. Ms. Kelshaw.
Yeah, just wanted to ask if the applicant could clarify that within the noise chapter that they're updating, that they're going to include a detailed mitigation or curtailment scheme if that's necessary, and also whether or not they were planning on updating any of the other chapters, just so that could feed into any further procedure that might be necessary.
Thank you. Yeah, you've got ahead of my questions, so that's fantastic. So yeah, Mr. Trinick, if you just confirm what's in that updated noise impact assessment, and also if it has any consequential changes for other parts of the EIA report.
Firstly, there are no consequential changes for any other chapters of the environmental impact information report. In terms of curtailment, CWP will see what's in the noise assessment when it comes out. Noise assessment is a complete noise assessment or reassessment based on the scope of the previous chapter. And that's all I'm prepared to say at the moment.
Okay, thank you.
Certainly, we will revisit the topic of CWP's involvement when we come to item 5 on the agenda.
No problem. Mr. Thompson, your hand's still up. Do you wish to say anything else, or are you?
gone white, so I presumed that had been cancelled.
Yeah, no problem. Okay, Ms. Holmes.
Just really, I'm assuming that there's going to be no change in layout for the wind turbines to make any difference to the noise. Or do we have to wait till the 6th of March to find that out as well?
Well, my understanding from what Mr. Trinick has said is that there'll be no consequential changes. Obviously, there's a micrositing allowance normally within wind farm development, so there might be some movement. But Mr. Trinick, if you could just confirm that there are no other changes.
The only other change relates to the tip height of some of the turbines. I was going to come on to that separately, but I'll come on to it now. A new set of visualizations is being produced for the inquiry. That will be ready by the 6th of March also. It'll be circulated electronically. Hard copies can be made available to each party participating in the landscape and visual evidence. It's not AI, since there are no new significant effects revealed by the visualizations, but they will show that the tip heights of 4 of the turbines have been reduced by 20 meters to 180 meters. And the tip height of 1 turbine has been reduced by 50 meters to 150 meters. These reductions are to meet the concerns of Glasgow Crosbie Airport in terms of their radar. But they are reductions in height. There is no change in the layout of the development at all.
Thank you, Mr. Trinick. Yep.
Can I come back on that just to say it will change the visual impact somewhat? So I take it these are not considered material changes.
That's there is the planning judgment for you to make, not me. From EIA point of view, no new significant effects arise.
Yeah, I think the important thing is that all parties will have access to those new visualizations prior to the hearing session, if that's what we have on landscape and visual impact. Thank you. We can, well, I don't want to get into evidence, Mr. Trinick, but I'm assuming that the applicant's proposing a restrictive condition in order to reduce those heights of the turbines. You're not looking to formally amend the application.
That's why I said by condition. That's how we will seek to secure that. There is one further point to note under item 4, if I may just quickly make it.
Please proceed.
Thank you. A reduced civil aviation lighting scheme has been submitted to the CAA for approval. If approved, this will mean that 7 of the turbines will be lit rather than all the wind turbines. We hope to get a speedy response from the CAA, but I can't tell when that will be. It'll certainly be before the inquiry. I think people ought to know that that's what we're doing. There are no consequences for the EIA, no consequences for the procedures towards the inquiry.
Okay, sorry, Mr. Trinick, does that mean that they'll be updated and at nighttime visualizations or?
No, so I don't think it will, in fact.
Excellent, thank you. Yes, Ms. Gould.
So I just couldn't hear very clearly what Mr. Trinick said about some of the changes. Do you think you could just repeat that, please?
Yes, of course, no problem. I'm sorry about.
Thank you.
Yeah, my apologies. The only changes are, well, there'll be no change in the layout. That's the first point. The only changes are the reduction of the tip heights of 4 of the turbines being reduced by 20 meters to 180 meters. And the reduction in height of tip height of 1 turbine by 50 meters to 150 meters. And those reductions are made to meet the concerns of Glasgow Crosbie Airport.
Thank you.
Sorry, further to that, I think there was a change in the aviation lighting which you proposed to the CAA. Is that, and that's reducing it from 14 to 7 turbines. Is that right, Mr. Trinick?
That's correct.
Brilliant, thank you. Mr. Thompson, and then I'll come to Mr. McKinnon.
Mr. Chenick said that he wasn't going to show the lights at night. With respect, that's probably going to be one of the sites that's going to be most visible. And it'd be an awful lot helpful if we could actually see what is predicted as the lighting pattern, because that is going to be a major impact on the local scene, and just to dismiss it would be inappropriate.
Yeah, thank you, Mr. Thompson. I don't think Mr. Trinick was saying he's dismissing it. I think the current visualizations would be relied upon, but obviously potentially with a lesser effect if there's 14 currently lit and there'll be 7 in the future. Is that correct, Mr. Trinick?
That is correct.
Thank you. Mr. McKinnon.
Yes, sir. Does Mr. Trinick know which numbers of turbines are going to have the height reduced?
Someone might ask me that. No, I don't offhand, but I will get that information and come back to you. I'm sorry that I don't have it to hand.
Thank you. I'd appreciate it. It'd help with turbulence questions. Thank you.
Right, Ms. Kelshaw, and then I'll come to North Ayrshire Council.
Hi, yeah, just had one question in relation to the reduction in the tip height of the turbines and whether or not that would have a consequential impact on the carbon calculator calculations of the application and the benefits that flow from that, and if that was going to be updated.
Mr. Trinick.
We are digging into the evidence here. It may or may not, I don't know. We'll let you know.
After this note of the meeting, Mr. Trinick, I'll put that in there, and if there is to be an amendment to the carbon calculator, perhaps if you could produce that at the same time by 6th of March, it'd be useful to capture all this information in one shot. Mr. Finlayson.
Thanks, Mr. Edwards. Yeah, can I request that the nighttime visuals are amended? It would seem to me to be a relatively minor matter to undertake, and also one that would ensure completeness of assessment. Thank you.
Mr. Trinick, I'm assuming I don't know how many nighttime visualizations there are, but is that something your team could do?
Yes, it probably is. The reason for a bit of resistance on producing further nighttime visualizations is that the reproduction of light on visualizations is at best an indication of what you're going to see. It's best to go out in the field and see existing turbines in order to make your judgments. But yes, we will do it.
Okay, thank you. Sorry, I can't see your last name there, John, but your hand is up, so you're next. Thank you.
Thank you. Again, a question for Mr. Trinick. Mr. Trinick, presumably the reduction in the heights and the blade diameters of the turbines does that result in a decrease in the power output of these turbines? And does it therefore result in a reduction in the power output of the whole proposed wind farm?
The answer is I don't know, nor do I think is relevant to the pre-examination meeting. We will produce the information. The carbon calculator we will update. If it's necessary in the evidence, we will update the output. Other than that, I can't say more at the moment. I'm sorry.
Thank you.
Yeah, if it helps, the application is for 80 megawatts plus 50 of battery storage. So if it's going below that, the one thing that I'd look to have updated is the carbon calculator. Ms. Kelshaw, your hand is up. I don't know if that's a remainder or you've got another question.
Yeah, sorry, I just forgot to add about the shadow flicker and whether or not that assessment would be updated following the reduction in tip height if it was relevant, just because I know that there are written submissions still to come on that chapter.
So I can answer that one very easily. I had it later in the agenda, but we appear to be having all sorts of topics at the moment. The the position has changed on shadow flicker. We are offering a shadow flicker avoidance, I mean total avoidance condition, supported by a technical note that will be submitted with the evidence. I'm not offering reduction, we are offering total avoidance. There will be no shadow flicker.
Thank you, Mr. Trinick. We'll get that confirmed in further written submissions. Now, is there any other questions in terms of item 4? No. Okay, we'll move on. So Annex A of the agenda sets out my view on topics requiring further procedure. To note, when I write my report to Scottish ministers, I will take into account all the environmental information submitted by the applicant, together with all the consultee responses, letters of representation lodged, and evidence arising from the inquiry process. The type of procedure being followed or the absence of any procedure does not affect the importance of a particular issue. The initial PEM, at that, I explained each of the various procedures that we can use to examine matters. Those are also outlined in the PEM2 agenda. Is there any question from parties about the various processes that are open to us? Yes, Mr. Trinick.
Yes, sir. Thank you very much. But we've been given some careful thought to processes. Might I deal with all the topics at once, or would you like me to deal with topic by topic and wait for comments?
Let's cover that under, we're going to come to that in just a second, and in terms of the process, but does anybody have a question about the particular processes? Start? Yes. Mr. Thompson, your hand is up. Mr. Thompson, are you there?
I think you might have answered the question by that last statement, but I gave you a supply of all the physical questions I had as to what the practicality of this. Will that be examined? Because it didn't seem to be appearing in the list of comments you'd received.
So as I understand it, at the first PEM, you raised that issue, and just let me check my notes. Is this a concern of yours, Mr. Thompson, in terms of the practicality of some of the engineering?
You should have a Crosbie practical items be checked on site by the reporter, which is what you requested me to provide you with.
Yes, so that was part of the site inspection request that I asked parties after the first PEM if they wanted me to look at anything, and you provided me with a list of things to look at on site.
Yeah, has that been done yet?
No, I haven't been on site yet, and with the push to the inquiry being in June, I'm looking at do the site inspections when the weather's slightly brighter.
I can understand that. I would appreciate it if you would ask me to accompany you, and then it'll be easier for me to show you the stuff on site.
Well, I think we had this discussion before about the practicality of getting on site with someone, and the practicality that I can't obviously go on site with one party. I need to go with other people as well.
That's very common. But the one we did on the original inquiry, the reporter invited us to be present, and it was a useful exercise.
Well, I'll put that under consideration, Mr. Thompson. In what I viewed of the visualizations and the invite for other parties to tell me where to go and look at locations, we haven't seen
a site inspection of all parties. I think would be useful to all.
Yeah, well, I would need to really know. I need to know what the value of that would be, Mr. Thompson, because I think I can see for myself, and if I needed any clarification, I could come back to parties.
Well, my fear is that the site hasn't been looked at that hard. We haven't seen them examples of the soil tests, for instance, to prove that the rocks are sufficient to support masts of this height. another 100 metres compared to the existing site. And most of the existing sites within the regional park are on what you call the plateau. So it's the parts that the applicant is suggesting is on the steeper up and down the original hills, as opposed to the plateau that is slightly behind the face of the hills, which is easier to sight the mast because you get a flatter surface. Some of the sites seem to be very restricted and quite difficult to erect the mast.
Okay, well, I have your comments on where I should go on the site to review that information, and I take on what you've said about location. Obviously, I've said also that there is a micrositing allowance for wind farms generally of up to around 100 metres. But I'll have a look, and if I require an accompanied site inspection for any reason, I would invite people to come to that. Ms. Gold?
Okay, under Annex A, there are two topics listed as having no further procedures needed, but I did have a couple of questions about them, if that's possible. So one was the ecology and nature conservation. I had a letter from one of our MSPs saying that Scottish Forestry was engaging with the Onshore Electricity Strategy and Consents Division about the woodland creation scheme at Monagh, and I don't know whether we see if that has happened. They've also mentioned the fact that the contract is for 20 years and payment might need to be refunded under that. I'm not sure if they've contacted you or where we can see any correspondence about that, please.
Okay, so we're jumping into the topics, which is absolutely fine. So I think under EIA Chapter 19 miscellaneous, I have down there that we still require further written submissions on forestry and access at Monagh.
Okay,
Would that
fine.
cover your?
Yes, those are the
cover
two
your
things
concern?
I wanted to ask about. The access, given the woodland creation scheme, that is a new woodland creation scheme proposed by Scottish Water, and issues about the access road, because as far as well, it's going into detail, but as far as I can see, the only gaps along the B780, there's one gap of 7 metres and one gap of 47.5 metres.
Okay, sure. Well, we're going to have
That's
a
later on,
topic.
is it? Okay,
That's a topic,
fine.
and we'll come to agreeing, but it sounds like we're going to look at further written submissions. So just looking at the topics.
Thank you.
No worries. Just looking at the topics, let's go through those again. So Mr. Trinick, I think you had some comments about the particular topics listed.
Not you know. But first of all, on noise, if I may, the first PEM notes show that there will be an inquiry session. In fact, the applicant and its consultants TNEI agree now think that a hearing session will be adequate to deal with the evidence, at least so far as the objections of Fairley Community Council, Dalry Community Council and Jackie Pearson are concerned. So I'm addressing those parties first. I'll come to CWP later. We believe that the nature of the evidence that will need to be given is such that a hearing session will be adequate. I don't expect the other parties to say yes just like that. I wouldn't. My suggestion is that we wait for the AI on 6th of March, and then within a period of, say, a week or so, up to you what period, so within a week or so of 6th March, parties can give their views on the need for which oral process, should it be a hearing session or should it be an inquiry session. You can then decide what is needed. Part of the reason for suggesting this is that when we come to timetable for the inquiry, it's going to be pretty tight in that first week because of non-availability of some people on some days. The hearing session is going to take a maximum 1 day, probably less. well, an inquiry session, more like serious, will take about 2 days. So I think we'll save a day, and I don't think we need an inquiry session. But I don't look for a decision on that now. That would be unfair. My suggestion is as I've made it. So that's so far as the Fairley Community Council is concerned. In terms of Mr. Walker's objection, and I stress Mr. Walker's objection, this is based partly on noise or other matters he raised in his letter of July 25. But it's in a different category to the other noise objections. Mr. Walker subsequently clarified that he does not himself live at Wardlaw, a house known as Wardlaw, and nevertheless he maintains his objection based on noise. Now, at the first pre-examination meeting, Community Wind Power expressed the wish to take part in the inquiry session on noise. Your note of the PEM records this. It did not specify that Mr. Walker, who is the objector, will be taking part. And CWP has not objected based on noise. Its position statement, issued to the DPEA, only specified weight loss as a topic on which it, well, primarily made an objection. It did not mention noise. Therefore, the position of CWP needs to be clarified. Does it wish to participate in the noise session on behalf of Mr. Walker? And why? And if it's altruistically supporting Mr. Walker, that's one thing. We can accept that. We're not convinced. We know that CWP is planning the life extension of Dalry Wind Farm, although a recent application has been withdrawn. Bluntly, is this CWP seeking to enhance its commercial position at Dalry by making a case against Crosbie, or is it truly taking part simply to support Mr. Walker's objection? Now, I note in this context that Mr. Walker is a senior employee, head of Scotland, called CWP. The further relevance to this to the Crosbie inquiry is that if Wardlaw is financially involved with Dalry, or perhaps another of the wind farms in the area operated by CWP, then the noise limit for such a wind farm will be higher at the property, it's for 45 dB or whatever it is, in which case, and this is the real relevance, the derived limits for Crosbie at that property could be higher and would be the case if Wardlaw was not so involved. So we need to know, for the purposes of the noise evidence of Crosbie, whether or not Wardlaw is financially involved with one of the CWP wind farms. And we need to know why CWP, which has not objected on noise, wishes to take part in Mr. Walker's objection to give evidence at the inquiry. This matter has been raised in correspondence. It was noted in an email sent to you by Stantec on the 3rd of December 25. We don't know, we need to know for the purposes of the inquiry. Thank you, sir.
Okay, thank you. So we've jumped into noise, which is one of the topics. Just to confirm, Mr. Trinick, before I ask CWP to comment, are you content with the rest of the topics in terms of, I haven't missed any topics?
I think so, so far as landscape visual effects are concerned. I have something to say later, not now, about the need to clarify the position of North Ayrshire Council. We're very happy on policy for a hearing session. We need to talk about aviation in more detail and perhaps separately. We're content with the conditions and obviously a community hearing session. My final point would be on weight loss, where I think this is a matter of going further in the submissions. That's the topic impact on neighbouring wind farms. In my view, following exchanges since the first pre-examination meeting, the competing figures for any weight loss can be put in writing with written submissions as to why they matter. Beyond that, the topic is really for closing submissions, including probably some legal submissions. But we don't need a process for that.
Okay, thank you. What we'll do, right, we'll tackle the noise issue first, and then I'm going to go through each topic very quickly in turn, and we'll just agree that the process is correct. And then moving into item 6, I'll look at the participation, who wants to be involved in each topic again. So in terms of noise, Ms. Holmes, I'll come to yourself first, and then we'll go to CWP.
Could you possibly go to CWP first, because what I've got to say might change once I've heard what they have to say.
Yes, of course. Ms. Kelshaw.
Yes. Yeah, well, I want to confirm that CWP do want to take part in the noise session, and we can confirm that the property is financially involved with our wind farms, as it was before it was purchased by Stuart Walker in any event. And the reason we want to take part in the noise session is a couple of things. One, yes, it's to do with the noise limit being appropriate for the property, but also in relation to the cumulative noise. Our wind farms, we believe, are currently taking up the noise limit, and that needs to be taken into consideration with Crosbie Wind Farm. And we've obviously got a consultant who's assisting us with that.
Thank you. So I think Mr. Trinick asked as well. So CWP is acting on behalf of Mr. Walker. Is that correct?
We're not acting on his behalf, but we're bringing the issue. We have financial involvement in that property, so it's in our interest to do so as well. But we'll be taking forward the issue in relation to the relevant noise limit of the property.
So sorry, just talk me through that. So CWP has financial involvement in that property, but it's owned by Mr. Walker. So is the CWP financial involvement because he's an employee of CWP? I just need to understand that connection.
Mr. Walker is an employee of CWP, but we're also the beneficial owner of that property. He holds it legally.
Sorry, it's probably me. I don't have a property conveyancing legal background, but you just explain to me, sorry. So what is the financial benefit for CWP? So this isn't the financial benefit's not just to Mr. Walker. You're saying it's to CWP as well?
Yes.
What? Sorry. Do you mind explaining why? Just for layman's terms for myself.
We own the beneficial interest in that property, and Mr. Walker holds it in his name as the legal owner, because he manages the property. So, but ultimately CWP has a financial interest in it.
Okay, thank you. Now, Mr. Trinick, I was under the impression that the updated noise impact assessment was to do with cumulative effects and what may or may not happen to Wardlaw Farmhouse. So there seems to be a connection there. Are you content under these pretenses for CWP to be involved in a noise session?
Well, that was quite extraordinary, but still, fact is, the objection was made by Mr. Walker, not by CWP. CWP has not objected itself on noise, looking at it from a planning perspective rather than ownership perspective. I'm not too, if CWP wants to run a case for Mr. Walker, the inquiry, indeed, it probably wants to run its own case, well, so be it. But I want to be quite clear as to why it's running a case and what case it is running. Now, if the argument is that Wardlaw Wood is and was financially involved with the CWP wind farm, that at least tells me, feeling, we know now, at last, that Wardlaw Wood is entitled to a 45 dB limit. That enables us to complete our noise assessment. We couldn't do it without that information. Secondly, we've now been told for the first time that CWP is the beneficial owner of Wardlaw itself, under a bare trust, under a legal ownership held by Mr. Walker. That is helpful information. Beyond that, sir, looking at CWP's objection as opposed to the objection of Fairley Community Council, what this tells me is we need to keep those two issues quite separate in the inquiry.
No.
Yeah, they are different. How we separate the evidence, we'll think about it later, but they are two distinct issues we're looking at here. So I maintain that for noise and Fairley Community Council, we can deal with matters by a hearing session. So far as CWP is concerned, and Mr. Walker, I reserve judgment.
Okay, thank you, Mr. Trinick. In terms of, yes, continue.
We just heard is really quite new to us.
Right, and then sorry, I'm going to come to CWP before I come to the other hands up. So, Ms. Kelshaw.
I just want to clarify that we did confirm that CWP were the beneficial owner of the property in our email to the Energy Consents Unit on the 10th of December. So this information has been disclosed previously. And in relation to the noise, it's the cumulative. That's the main concern for us in relation to the wind farms and the noise limits that are applied to Crosbie. The property and that having an appropriate noise limit is also an issue for us, but the main issue is the cumulative noise.
Yes, I mean, we can't get into evidence today. I just have I have an issue here. I think I'm going to have to write to parties to clarify this, but what noise limits actually apply to Wardlaw Farmhouse? Because if we've got the applicant providing additional information and an updated noise impact assessment, but we don't know the parameters that we're working on, that could be quite ticklish down the line. So, Ms. Killshaw, can you confirm that just now, or is that something that I can confirm in writing?
Yeah, we can do that in writing. I can't confirm it right now.
Okay, Mr. Pick, and then I'm going to come back to Mr. Grosvenor and Ms. Holmes.
Thanks, yes. From what I've heard today, I think it'd be helpful for you to receive information from CWP, possibly from us, but in response within a short period after this pre-examination meeting, so that each party can inform you of its view of the best process to take this forward, and you can make your decision.
Thank you. Yeah, I agree with you, Mr. Trinick, in the sense that I think there's two distinct elements to the noise now. And I'm wondering whether or not the effects that have been raised by Fairley Community Council could be captured within a community hearing session, or if they actually need a bespoke noise session. Are you shaking your head, Ms. Holmes? So I'm assuming not. So I'll come to you next, Ms. Holmes.
Just really that Fairley Community Council is not just interested in noise that's going to affect our village. We're interested in the whole development to do with the noise. We can see the distinction between the noise element for Wardlaw Farm and Community Wind Power's argument that they were going to steal the wind from them. We can see the distinction in that, but you cannot separate the noise just because that's a separate property. You're going to look at cumulative noise, which is what Melvin, I think, is going to be doing for us as well. We do not want to be separated out because I think it's a way of weakening our arguments. It's a clever way of trying to weaken our arguments. We would see it as that. But Melvin might totally agree with me or disagree with me, so I'll let him have a bit of a say.
Okay, Mr. Grosvenor.
Yes, I mean, it's very interesting and thank you for this clarification, but our red line is that Wardlaw Farm at the moment is a residential property. The email that came from Stuart Walker, Community Wind Power, confirmed that Mr. Walker wouldn't be living there, but he said, or the email said, that that property would be rented out. Now, that raises serious issues as far as we're concerned, because residential amenity regarding involved and non-involved properties is part of the application. Now, whether it's split to Community Wind Power or Galileo, Crosbie, we need to look at that. The fact is, at the moment, as it stands as a non-involved property, we haven't seen, and obviously we'll be interested to see what the reassessment is on the 6th of March. But the current position is that there are exceedances at Wardlaw Farm from the proposed operational turbines. It's difficult to see how changing the blade tip height will rectify that, but again, we'll deal with that when we come to the evidence. But the bottom line is that Wardlaw Farm is an existing residential property. Whoever owns it, and as such, the amenity of that property needs to be protected. And we can't see how, if the cumulative noise limits are reapportioned, we will want to have absolute clarity that the amenity at that property would be protected however that is devised. Now, it is complicated. I've never come across a situation like this before, so there is a bit of muddying of the waters here. But our position will be based on what we see in the revised impact. But if there are issues, then we will be content to raise those at the inquiry as we come forward. And therefore, either there is a hearing on this or there is an inquiry session. Wardlaw Farm and the outcome of Wardlaw Farm's assessment is absolutely becoming a pivotal issue within this application as far as wind turbine noise is concerned.
Okay, thank you, Mr. Grosvenor. So I assume you're open to either oral process, so a hearing or an inquiry.
Sorry, could you repeat the question?
Yes, I was just wondering, you seemed to be at the end there that you were saying you were open to having either a hearing or an inquiry. You're not holding a flag up to one or the other.
Well,
I think we would want to reserve judgment and have a discussion on that.
I would agree with Ms. Holmes on that. I mean, we don't know at the moment what the revised updated noise impact assessment will be. So we don't know. I mean, we'll have to obviously wait. And as Mr. Trinick quite rightly said, if we have 6 days or a week to decide our position after the 6th of March, that seems a sensible option.
Okay, thank you. I mean, Mr. Trinick from the outset said that following the additional information, which would come in the 6th of March, I could make a quick determination on what process that we would embark upon. And just looking at the indicative timetable, confirmation of parties' participation is also the 6th of March. Inquiry statements would be due, or outline hearing statements if required, on the 20th of April. So that would seem to myself to be sufficient time, albeit tight. Now, Ms. Parsons, your hand's up, unless Mr. Grosvenor, you had something else to say because your hand's still up.
No, sorry, I'll take that down. Thank you.
Okay, Ms. Parsons.
Right. The last meeting, I was told I couldn't comment on the ornithology because I was too late. But it was just something I thought I should bring up, because the company run the risk of breaking the law, because when they carried out their bird surveys, they didn't map.
I'm conscious that this is a live stream.
Okay.
We have to be careful in terms of our legal responsibilities of disclosing any particular species about where they might be located. So if you just tread carefully.
Oh, no, it's fine. No, it was just that they failed to map 2 species, meadow pipit and skylark, which are the 2 species that are most affected when you build a wind farm. Because I've worked on a number of wind farms, and you have to know what the situation is regarding these ground nesting species, because they get disturbed when you're building the turbine bases and access tracks, and it involves an awful lot of work by competent ornithologists with nest finding experience to find these nests, and it holds up the work. And I am constantly unpopular because of that kind of work. Now, this company hasn't even bothered to mention these 2 species And, you know, I was wondering how on earth are they going to get round this, you know, because they're going to run the risk of breaking the law by disturbing and destroying nests, because they are going to be building during the spring and summer bird nesting season. But I just find that a huge omission in the ornithology report. And because it could lead to, you know, them breaking the law, I felt I should bring it up, because we will be watching. And if we see nests being disturbed, we will call the police. So I think it's vital that they're aware of this. Okay.
Thank you, Ms. Parsons. I'll tell you what I would generally do in these circumstances. I will look at the environmental information that's been submitted and the consultation responses from Nature Scot and RSPB Scotland. Generally in these processes, there's something called the scoping stage, where the particular species are either scoped in or out. And so there may be some information behind that. But obviously, the provisions of the Wildlife and Countryside Act 1981 would apply to any developer doing any development. And I have to admit, I haven't read fully into the EIAR, so I can't tell what the mitigation of that is right now. But if I find that there's an issue with that, I would, of course, look to investigate it further as a legal matter. Mr. Trinick, any comment?
No, obviously we can't mention the species on live stream, but if Liz Parsons would like to contact us, she may have done already with the names of the species, and my apologies if I don't know. But if you haven't done it already, do contact us with the names of the species and your concerns. This may be a case for further written submissions. I don't know, but let's find out.
Okay, right, yes. I'll get a note to you.
Thank you. Yeah, I think the issue before was that perhaps it wasn't a pre-disclosed concern in the objection, but you've highlighted it now. So I'll look to liaise between you both through this meeting of the notes to make sure that that can happen.
Right, thank you.
Okay, right. Let's just go back to noise. So we've agreed that noise is a relevant topic. I think it's difficult for me to pull this apart. So I think at the moment in my mind, it has to be one noise session, either a hearing or an inquiry. But I don't think I can make that decision until I have the additional information. I don't think we can complete the additional information until we're aware of what the current noise limits are for Wardlaw Farmhouse. So within the next 7 days, I'll get that information from CWP, and we'll make sure the applicant has that input into the updated noise impact assessment. And then we can proceed. And once the AI comes in the 6th of March, I'll very quickly confirm hearing or inquiry, but there will definitely be one or the other. That will be difficult for us programming, because obviously hearing, as Mr. Trinick says, will likely be 1 day, whereas an inquiry probably 2. Are parties content with that approach? Yes. Mr. Grosvenor?
Yes, yes.
Yeah, Ms. Kelshaw?
Yes, we're happy with that.
Okay. Thank you. Okay, we're going to nip down through all the topics briefly as we go. And obviously I'll be looking back at the procedure notice 2, which actually sets out who I thought originally was going to be involved in these processes. Mr. Thompson, your hand's up. Mr. Thompson?
It is beside the people living in the cottages, there's going to be people walking and working on these hills. And again, the health and safety requirements to be met.
Yes, thank you for that observation. Yep, that's correct. You mean during construction and operation decommissioning phases? Yes.
Yes, it will apply right across the whole process of the erection, use, and demolition.
Yeah. Okay, thank you, Mr. Thompson. That's noted. Okay, so topics 1 to 4 of the EIA paper, no further procedure. That's agreed by parties. Yep. Sorry, Mr. Thompson, were you saying something else?
So could you just read through? So could you read through the 4 items? I haven't got the agenda immediately to hand on.
Okay, so the first one is the introduction, description, site selection and design evolution and methodology of the environmental impact assessment. No further procedure. So that's agreed by parties. Yep. The next topic is policy and legislation, of which we're having a half-day hearing session. That's agreed by everyone? Yes. Okay, now, participation in that hearing process would be the applicant, North Ayrshire Council, and then I have the following, CWP, West Kilbride Community Council, Dalry Community Council, and Mr. Thompson. Is that correct, and or should I add anybody else to the list? If anybody's not content, just tell me and I'll amend that. Okay, so I mean, after this PM note goes out, there's 14 days where anyone can opt into any of these processes if I've omitted you for any reason. Yes, Ms. Parsons. You're on mute.
Oh, sorry, I was just checking that my hand wasn't still up from the last time. No, so I've got nothing to say, thanks.
Okay, just pop your hand down then. Thank you. Thanks. Okay, so that's agreed. After climate change topic, no further procedure. Agreed. Yes, obviously there might be an issue with updating that environmental information. Noise and vibration, ground conditions, peat hydrology, flood risk and water risk resources. We've already had written submissions on those 3 topics. I don't envisage requiring anything further other than noise, obviously, which we're going to. So is that correct? Parties content with that? Ms. Gould.
Okay, I wondered if it was still possible to comment on the applicant's written submission. I know it's beyond the date that was asked for. As procedures are pushing into June now, could I still comment on that, please?
Yes, which written submission?
Well, I made, along with Dr. Duckett, a written submission about the hydrology flood risk.
Yes.
And the applicant put their comments in. Am I still able to comment on their written submission, please?
Not generally. Generally, it's there's a 2-stage to further written submissions. It's you comment on the questions and then you get another 14 days to comment on what the other party has said. However, if there's something outstanding that you'd like to come back on, yes, I can allow another period for you to comment and for the applicant to comment again. So
I would appreciate that if that's possible, please.
Is there a particular element of that?
Not one of them. I just want to be able to, I know it's out with the time requested. I would like to make some more comments on the information that they replied with. Okay,
so as long what I'm wary of is the introduction of new matters or new information, and then we protract this, it carries on with more and more further written submissions. So if you're responding to what's already been said, I think that's perfectly acceptable.
Yes, I want to respond to what they have said, if that's okay.
Yeah, no problem. Okay, we'll set that up.
Thank you very much. Appreciate that.
I take it that's acceptable to yourself, Mr. Trinick? Yeah, right. Okay. Ecology, nature conservation and ornithology, we have then is no further procedure. Is that agreed with parties? Obviously with Ms. Parsons' comments from before taken into account. Okay. Landscape and visual impact, including aviation lighting. I have that down as a 1-day hearing session. Is that still agreed? Yeah.
So,
Yes. Yes, Mr. Trinick.
to raise my point then, all we have in terms of the position of North Ayrshire Council at the moment is a reason for objection, which is in very general terms, and the position statement, which adds not very much. Since the date of those documents, Carol Anderson has been instructed to give evidence. You provided for outline hearing statements to be submitted by the 20th of April. If the North Ayrshire case is going to be different from that which we could reasonably anticipate on the basis of the reason for objection and the position statement, that could lead to, well, it could lead to prejudice. My request is that we should receive an outline hearing statement from North Ayrshire Council by, say, the second week in March, rather than waiting until the 20th of April. That gives us adequate notice to our evidence. Given the submission date of the evidence, myself is going to be on the 18th of May.
Yep, notice Mr. Trinick. Mr. Finlayson, would that be something that's possible?
Yeah, I think so. I think the second week of March may be premature though, Mr. Edwards. Just if I could give some context here in response to Mr. Trinick's question. I have an email from Mr. Welton of Monday of this week, 3:27 p.m. I was on leave, returned from leave on Wednesday, and it's my intention to respond to Mr. Welton's email in due course. Quite understandably, we'll appreciate I've waited until the PTM was concluded to do that. What I would say, in giving some context and some reassurance to Mr. Trinick's question, is if Mr. Edwards, if you recall the council's position in respect of requesting a hearing session on landscape and visual impact, that was to facilitate an open discussion on matters of landscape and visual impact. It's not the council's intention to in any way obfuscate that. What I can't answer today, but will in response to Mr. Welton's email, is the council's position in respect of matters under consideration. That will require further discussion with Carol Anders Associates, so it may not be possible to do that by the second week of March, but I'll advise Mr. Welton of that in my response.
Thanks very much.
Okay, I'm obviously not involved in those communications between Mr. Mr. Walton and the council. Mr. Weeson, is it? I take it that's between the applicant and the council. You're having discussions about this privately. Yes, Mr. Finlayson.
Thanks, Mr. Edwards. Yeah, Mr. Welton emailed me, as I say, on Monday. There was an email to yourself 2 months previously in which the matter was raised by Mr. Welton, but not directly to myself. Therefore, I didn't see the need to respond unless directed. And of course, frankly, wouldn't have been able to on the basis of we had no discussions at all with our landscape consultant on that basis. But so subsequent to that email to Miss Bailey, I can give you the date of that, on 19th of November from Colin Levetti. That was forwarded to me yesterday, on Monday at 3:27, and I will be responding on that basis. And I'll copy yourself in, Mr. Edwards.
Thank you, that'd be great. And in terms of, you said it might be a bit premature mid-March, would a further week be acceptable?
Yeah, I think that would be absolutely fine. Yeah, I think a further week. It's simply because of the chronology and our frankly nascent discussions with Miss Anderson, but an extra week I'm sure will be absolutely fine.
So that's fine, but I would point out that the email to which Mr. Finlayson refers is that from Mr. Welton, pointing out that we requested this information more than 2 months ago. So we are now making it the medium of the pre-examination meeting so as to get a response.
Yeah. Well, it sounds like Mr. Finlayson's on board with that, so we'll get that moving now. Now, in terms of those involved, for that session, we said, obviously the applicant, North Ayrshire Council, Fairley Community Council, West Kilbride Community Council, Friends of the Clyde Muirshiel Regional Park, Dalryle Community Council, and Mr. Thompson. Is that correct? Am I missing anyone? No, perfect. Thank you. All right, moving on. Archaeology and cultural heritage, traffic and transport, socioeconomic effects, no further procedure. Is that agreed? Yeah. Now, aviation. There was a question mark over this, and obviously I've put everything on hold for aviation. So at the first PEM and from discussions, there's outstanding objections from Glasgow Prestwick Airport, Glasgow Airport, and NAT Safeguarding in terms of radar interference. Can those parties give me an update on where we are? I'll start with, well, who would be best? NAT's Safeguarding, if you could tell me where we're at.
Yeah, we have a limited communication with the applicant since the last PM. Our position remains that we believe this development to be ultimately mitigatable, but we are not there yet.
Okay, I'm just going to go to Glasgow Airport and then Glasgow Prestwick Airport, and then we'll have a little discussion about when we might know, because I think I'd set a date early December originally for any agreement to be done. So let's see where we're at. Glasgow Airport.
Yeah, so the headline position for the Glasgow Airport remains that there's an objection in relation to radar and an objection in relation to instrument flight procedures. Both of them remain. Parties had been in discussion prior to your December date, and I understand that I think it was on a joint basis from the applicant's agent, copied and consented to myself, that we indicated to the DPEA that those discussions were ongoing. There hadn't been resolution. We then were proceeding with the timetable that you had set from the previous meeting, sir, which was subsequently suspended prior to Christmas. Since then, we have engaged in relation to the new aviation matters submitted to you via Shraven Airfield, which obviously hadn't previously been considered. There have been further discussions between the Glasgow Airport and those instructing Mr. Trinick and the applicant. Those discussions remain ongoing, and if you forgive me, I don't think I can go into too much more detail regarding the substance and detail of that, but discussions are ongoing and information is being exchanged.
Okay, thank you. Glasgow Prestwick Airport, just I understand that the reason for reducing tip heights is to navigate your own objection. I don't know if that's would that mitigation itself would be successful to alleviate your own concerns, or if there's still outstanding ones.
So, sir, we have made significant progress in our discussions with the developer. As Mr. Trinick explained, it is proposed, the reduction in tip height is proposed to address our objection in relation to the impact on the airport's published instrument flight procedures. There are also objections in relation to impact on radar and VHF. Glasgow Prestwick Airport is reasonably confident that we will be in a position shortly to be able to withdraw our objections subject to the imposition of conditions. We expect that by the end of February, possibly early March, we will be in a position to do that.
Okay. Now, I'm going to come to Stephen Airfield in a minute, but I feel that that's slightly a separate matter. So for myself, in trying to organise an inquiry and fix dates, and we're already at the minute talking about a noise session, which may or may not be 1 or 2 days. And we talked at the first PM about how long would we need for an aviation inquiry, and how long is a piece of string seemed to be the answer. So I'm concerned that we're already into February. It's been a long time since the first PEM. I'm not sure. I understand commercial confidentiality comes into this, but people being confident there's mitigation, I really need to know quite soon whether there's going to be a withdrawal of these objections. Mr. Trinick, I'll come to you and then I'll ask the other parties.
Thanks. Taking the easy ones first. NATS. Yeah, I think the joint confidence that we will reach an agreement and reach an agreed wording for a condition. I think both parties are not putting any blame on NATS. We need to expedite that. But I think we can get there by early March, is my understanding. Glasgow Prestwick, very grateful to them for their cooperation. It's been very much appreciated. And I think there's a level of confidence that we will see a withdrawal of the objection by early March. And I'm grateful to the Fiona for a confirmation of that. In relation to Glasgow Airport, it's not quite as rosy as painted. We have been seeking information for months from Glasgow Airport in relation to instrument flight procedures to inform what we do. Only there was a call earlier this week from Glasgow Airport apologising and some promising urgent attention to the matter, but we still await the IFP information. We can't do anything without it, so I really would urge Glasgow Airport, having been chased, and I've got a record of all the times we've chased them on numerous occasions since December, and yet nothing has happened, to get on with it and provide us with the information so that we know what we can do about it and so that you know whether there's an issue to explore as inquiry. It's been rather aggravating trying to get progress. So.
Okay, back to Glasgow Airport. Could you just give me an update on where we're at, whether the information has been shared with the applicant, and if it's not, when it will be?
I had a call earlier today with the airport. I understood that they had gone back with that information. That may have been today. If I've got that wrong, I apologise, but certainly my client is on the call as well. They'll have heard what Mr. Trinick has said, and that information such as we have can be expedited. I can't say much more than that, because if I've got it wrong that it was transferred, then that was passed on, then that's my error in my notes. But I see Mr. Trinick has his hand up.
Okay, Mr. Trinick, thank you.
Yes, some information was received, but unfortunately it's information we can't use. The information was specifically requested using what's called TRAX, T-R-A-X, the data. The information which has been sent does not relate to TRAX, and it's unusable. We'll come back to you direct on that, but would urge you to respond quickly when we do come back to you.
Yeah, so
yes, sir, I've heard that, and if either direct to the airport or from Shepherd and Wedderburn to myself, if the questions or the request can be framed, it will be expedited to the extent that it can be.
So from my point of view, if we're looking at wrapping up NAT safeguarding Glasgow Prestwick Airport by early March in terms of a suspensive condition to alleviate their concerns, I would highly endorse that Glasgow Airport work with the applicant to aim for the same. So I'll put it in the note. I need to know by early March. Otherwise, we're looking at an inquiry on those matters. I'm trying to understand, are Glasgow Airport's concerns not similar to NAT's?
So the airport has, there are two aspects to their objection. There's the changes that would be required to the instrument flight procedures, which isn't simply in the gift of the airport. It will require approval by the Civil Aviation Authority. And then there's a separate issue in relation to radar mitigation. There are, in a number of these, wind farm developments in and around the airport, mitigation measures have been able to be entered into, and in those circumstances, objections have been withdrawn, subject to an appropriate condition being put in place. So the two strands remain at this time, sir.
Okay, so just for me planning, if we were to hold an inquiry, I presume would inquiry be the best way to resolve the radar and flight instrument issues?
In particular for the instrument flight procedures, yes, the airport will be looking to lead expert evidence on that.
Okay.
Radar may be able to be done in, sorry for speaking across you, radar may be able to be done in written submission, but certainly inquiry for IFP issues.
Okay, well no, thank you, that's good. So further written submissions for the radar potentially, and then the IFP through an inquiry. So maybe just one witness?
Certainly one expert, but I imagine we'd also require someone from the airport in case slightly wider issues come up that the expert can speak about IFPs, but if there's a specific Glasgow airport implementation of them or wider airport matter, I would expect a factual witness to be available to avoid delaying the answer to questions you may have, sir.
Brilliant, thank you. Mr. Trunick, your hand's up.
Yes, I agree that we can deal with the radar issue by written exchanges. I agree we need oral process to deal with the IFP issue. Whether or not we need an inquiry as opposed to a hearing session, can we reserve judgment until we see what Glasgow Airport sends to us?
Yeah, yeah. Okay. As I say, this is somewhat frustrating in that it would be nice to be able to put down exact when we're going to do things and what's going to happen, but I understand there's moving pieces here. So if we can get NAT safeguarding Glasgow Prestwick Airport wrapped up by early March and aim to do the same for Glasgow Airport, and if we can't by early March for Glasgow Airport, at least have an indication of further written submissions and an inquiry or hearing session on IFB. So that seems to be agreed with parties, is that correct?
Just for completeness, sir, if there are any, I'd reserve my position in any of the new aviation matters, which I think you are moving on to the extent that they, on the two original issues, I agree with your summation, sir.
Yeah. Okay, well, let's move on then to Straven Airfield. We've had written exchanges, Glasgow Airport have been involved, the applicant and Straven Airfield. So are those sufficient? Do parties feel that that's taken us sufficiently forward, or should we investigate the matters raised further? I'm going to go to, can't see your name up here again, but is it Mr. McKinnon from, oh, there we are. Mr. McKinnon, thank you, from Straven Airfield. Your thoughts initially?
Thanks, sir. Our thoughts initially are that I think we've outlined pretty much the situation. I have one concern hearing that Prestwick Airport might be lifting their objection based on radar and instrument flight procedures. And there was no comment made on Prestwick Airport's response to our original objection, where they did indicate that they could foresee similar problems to ones that we had raised. And there's been no discussion about how those might be mitigated, if they could be mitigated.
Okay, so just in summary, Mr. McKinnon, you were content with the further written submissions between parties, but you're seeking a reply from Glasgow Prestwick Airport on the concerns that you raised.
Yes, that whether they are still have those concerns, or whether, as seemed to be indicated earlier in this meeting today, that they thought all concerns were in the process of being removed.
Okay, can you remind me what that concern was? Thank you.
Yes, basically concerns in respect to the reduction of the vertical height of the airspace, concerns about the creation of a choke point in the Hunterston area, concerns about communication in terms of particularly VHF radio, and concerns on workload for air traffic control.
Excellent. Okay, thank you. Mr. McGregor, would you like to comment on that, please? Oh, sorry, I see Mr. Thompson's hands up.
Yes,
So I'll just
he's
come to Mr.
probably
Thompson.
better placed.
Thank you, sir. Just in reply there, I think we put quite a detailed response to the original procedure note number 3 that you requested pre-Christmas. We're content with what we put in there. The discussions that we have with the developer would get us to a place where we were comfortable to remove our objections subject to the appropriate suspensive conditions. In respect to the wider stream of issues that are being raised here, quite a few of our feedback to that was also taking cognizance of the Glasgow airspace change that's currently going on as well. So I feel we're comfortable to lead to our position is as we articulated to yourself in that response to procedure note 3. And I really don't think we've got much more we could add to that process at this stage.
Okay, thank you. Mr. Trinick, do you have any comments?
No, sir. I think that further written submissions would be appropriate to deal with the Straven issue. Happy to engage in them. No more to say.
Okay, so if I review those submissions and see whether or not we require further exchanges and they would be in writing, are parties agreed with that? Mr. McKinnon?
Yes.
Yeah. Sorry, Mr. McKinnon, just hearing from Glasgow Prestwick Airport, do you feel that there's anything that hasn't been responded to in your concerns?
No, not at all. I'm grateful for that clarification.
Thank you. Okay, well, we'll move on then. So shadow flicker, that would be between the applicant and CWP in relation to Wardlaw Farmhouse. Mr. Trinick's indicated that there would be an avoidance, a complete avoidance of shadow flicker. So I'll get that in writing. Is that acceptable to yourself, Mr. Trinick, and to CWP?
Yes, to us.
Yeah, Ms. Kelshaw?
Yeah, is that going to come with the updated information on the 3rd of March, or 6th of March, sorry?
The technical note will be ready by then, but I will check that before I commit.
Okay, and then we'll have an opportunity to respond to that information. Yeah, that's fine. Happy with that.
Yeah, any further written submissions always involves anybody with an interest, and there's an exchange between each, so you both get an opportunity. Telecommunications, no further procedure. Everyone's in agreement with that. Miscellaneous, we're going to have further written submissions on the forestry and access at Monagh. So I'll include yourself, Ms. Gould, and the applicant. Is there anyone else that requires to be involved? Did you say Scottish Water has an interest in that?
Yes. Well, I'd sent some information via Hazel about a letter I'd had from Bell Ingram solicitors who are acting for Scottish Water, and they are planting new woodland in the area of the proposed access road.
Okay, so I propose that I put together a further written submission to Bell Ingram on behalf of Scottish Water, yourself, Ms. Gould, and the applicant. Just getting clarification.
So the contact at Bell Ingram is Tony Wilson.
That's fine. If you forwarded it on, we'll have that. Yeah, thank you.
Okay.
Mr. Trinick, are you content with that?
Yes, answer.
Okay, thank you. Cumulative impacts, no further process other than those in relation to LVAA and noise. Summary of mitigation, no further process. The conditions and potential for legal agreements we have down as a half day, albeit in my experience, normally a quarter of a day is sufficient. Parties content with a hearing on that? Mr. Trinick?
Yes, sir.
Yeah. North Ayrshire Council, you'll be involved. Are you content?
Yes, Mr. Edwards.
Before I come to yourself, Mr. Riddle, I'll just check here. I think. Yes, we'd also included Fairley Community Council to come along to that and CWP. So I'll just ask Fairley first, Mr. Grosvenor, Ms. Holmes, if you want to confirm that you want to participate.
Yes, certainly in the noise condition, sir.
Yes. Super. Ms. Kelshaw, is that correct?
Yes, that's right. And just to check that we will be involved in the draft conditions being circulated prior to the hearing session.
Yes, I'm going to come on to that. But yeah, that was agreed previously. Mr. Thompson, your hand's up and then I'll come to yourself, Mr. Riddle.
Yeah, my query is, as a surveyor, I found picking out the boundaries posed for the site quite difficult in that they didn't seem to follow existing boundaries and was going through the middle of blocks and items like that. And I'd really appreciate Mr. Trinick explaining to me how he expects the boundaries to sit out and to operate. It just out of curiosity.
Sorry, Mr. Thompson, just for one clarification, do you mean physical boundaries or do you just mean the red line of which encompasses the application site?
Get the camera. Right. Yeah. You're talking about the boundaries here. You're going across the top end of the Knockandoo Reservoir. You're going through the middle of Glenburn Reservoir. You come to a point here. There seems to be the last turbine 5 is just on the south of the waterfall going down to Fairley, but the ground extends out beyond the boundary walls that have been established by some probably 500 meters. And, it just strikes me as being a bit difficult to determine on the ground exactly where the boundaries are and why the boundaries are there.
Sure. Well, I can ask Mr. Trinick if you have a comment on that before we move on.
I haven't got a clue. I think the best thing is outside this meeting, Mr. Thompson, get in touch with us and we'll do the best we can. If you're asking a lawyer to fix boundaries, that's very unwise.
You're speaking to a good surveyor, so let's look from that point.
Okay, I'd
appreciate a chance to talk. It's, as I say, curiosity. It just seems to be difficult, especially where some of the water courses feed into the fish farm, which is also part of a mini hydroelectric scheme.
Okay, well, I'll set that up so there's a liaison there between yourselves. Mr. Riddle, you had your hand up.
Yes, my apologies, sir, but I think you agreed after the last pre-inquiry meeting that I could participate briefly in the landscape and visual impact hearing session. I think that was confirmed by your secretary.
Yep, that's no problem, Mr. Riddle. I'll just note that down. Okay, I've done that.
Thank you very much.
No problem. Thank you. Okay, so conditions are agreed. The impact on neighbouring wind farms, that was just between the applicant and CWP half day to look primarily at vortices and also to potentially talk about the carbon calculations between the two sites. Mr. Trinick, and then I'll come to Ms. Kelshaw.
So I did the leads oral process. This is a matter for written exchanges. I think as I said earlier on, the competing figures for any weight loss can be put to you in writing with submissions to and fro as to why they matter. And then it becomes a matter for closing submissions, including, I suspect, some legal submissions as well. But I do not think we need oral process for this, nor do we need oral process for the carbon calculator.
Ms. Celshaw, any comments there?
Yes, DWP would prefer to have an oral session on it. They were happy with the hearing session. Obviously, we don't know what new information is going to come forward on the 6th of March. The scheme has slightly changed with the tip height reduction, so the information will be different. So, you know, we would say we would still want a hearing session. And no decision could probably be made today, and judgment should be reserved, I think, until we get the additional information.
Yes, sorry, we're again entering into an inquiry situation in June where we're looking at so many flexible days and obviously booking a location and organizing travel and all that kind of thing. Can I just check so that the changes in tip height, they have a correlative effect possibly, and I don't want to get evidence now, but on the vortices, is that what you're looking for?
Yes, that's right.
Okay, so the additional information comes in 6th of March. I propose I put out further written submissions at that point, and on the basis of the responses, determine whether or not there's actually any necessity for a hearing. Is your thumbs up, Mr. Trinick? Ms. Celshaw, does that seem like a sensible approach to you?
It seems fair, yeah.
In effect, I'll probably put a save the date for the hearing. So we'll probably have a half-day session allocated, but we may not need it. Okay, and then in terms of the community hearing session, are we all content that that is a hearing and that it's half-day? Yes, okay. And is there any other party that wasn't listed before that would like to be involved in that session? No, so I have the applicant, North Ayrshire Council, well, actually, sorry. I have the applicant, North Ayrshire Council, Fairley Community Council, West Kilbride Community Council, Friends of Clyde Mearshall Regional Park, Dalry Community Council, and Mr. Thompson. Is that correct? Yes, Mr. Duckett.
Yeah, I believe that I was supposed to be part of that as well.
Excellent. I'll add you on, no problem. Ms. Gould, your hand's up as well.
I intimated that I would like to be part of that after the first PEM. Can I also ask just a general question, please?
Yes. Yeah.
I've heard conditions being mentioned a lot, and also conditions were mentioned in the written submission about the flood risk. I'd like to ask, who enforces conditions? Could you tell me a little bit more about the procedure for conditions, please?
Yeah, sure. So the report to ministers, whether or not it's recommended for approval or refusal of the application, there'll be a series of conditions attached. The first batch of those are ones endorsed and applied through the Section 36 consent, so through the Electricity Act, and those are enforced by the Scottish ministers. And then the others are what we call deemed planning conditions. So when you get an energy consent, you also get deemed planning permission. And so there would be basically planning conditions attached as well, and those would be enforced by the planning authority, generally in consultation with any relevant body. So I hope that answers your question.
Well, the reason I'm asking is that just an example that's already happened at Munnock in planning that went to the local authority, conditions were attached which were not fulfilled. And my understanding there was some discretion on whether they had, the conditions could be attached but wouldn't necessarily be enforced. So I'm assuming that in this situation, the conditions are always enforced. Is that correct?
Well, I can't comment on behalf of North Ayrshire Council, but as a general rule, enforcement is only taken where it's necessary and expedient to do so. So
no, I'm asking just about this. I'm not asking about what happened with that. I'm asking in this situation with these developments, are the conditions always enforced?
Well, I mean, I can't comment on that because I'm not the local planning authority. So it's the local planning authority's remit to investigate and enforce those conditions that are attached to the planning consent.
To this
So for
consent, yeah. To this
or any
consent.
other, yeah. So Dalry Wind Farm, for example, will have a set of deemed planning conditions. If an issue arose with, say, noise, it would be for the council to investigate and decide whether or not those noise conditions were breached and whether or not it wished to proceed with enforcement action.
Okay, so it's the same procedure when it's under the Electricity Act as if it was a local planning issue. Is this what you're saying?
Yes, for the deemed planning conditions, for those that the minister sets out, so that might be something to do with the radar mitigation scheme. It would be for the ministry to decide whether to intervene.
Okay, thank you.
But I think if you've got any further questions about enforcement, the best port of call would be Mr. Finlayson. Is that correct, Mr. Finlayson, or have I overstepped there into your territory?
Well, a little with respect, Mr. Edwards, yeah, but I think the most important point to note here is that in respect of Ms. Gold's question, is that the council, of course, will be engaging with the applicant in respect of draft conditions. The council, as planning authority, would always urge any reporter to take cognizance of the council's comments in that regard, which, in particular, in respect of the appropriateness of conditions in respect of planning circulars in relation to their enforceability, for example, the reasonableness and the various tests applied. And that process should ensure that the conditions attached to any grant of planning permission through an appeal process would be robust and enforceable. The council thereafter has its enforcement charter, which is approved by Scottish ministers, and the council would engage any enforcement matters in respect of that charter. But at the moment, this is a hypothetical question, Ms. Gold, but certainly if you wanted any questions answered in more general terms, this being hypothetical, of course, because no planning permission has been granted here. But if you have any questions specifically in general terms, I'd be happy that you direct them to me in respect of either what may happen with this inquiry or any previous grants of planning permission.
Thank you very much.
Thanks, Mr. Finlayson. Right, thank you. I think we've got agreement there. We'll come on to how we're going to plan this all in a second. So we previously agreed that statements of agreed matters would be produced from those participating in any inquiry or hearing session, and that the applicant would take the lead in producing those. Is that continued to be agreed, Mr. Trinick?
Yes, it is.
Thank you. The applicant also agreed to work with other parties to prepare a draft set of conditions using the Energy Consents Unit standard conditions as a starting point. Those participating in the conditions hearing session should be invited to comment on those conditions, and statutory consultees should also be invited where relevant. Is the applicant still agreeable to organising that?
We are agreeable to organising it, but we'd rather do it in two loops. One with North Ayrshire Council as the enforcement authority in due course, and secondly with other parties.
Yeah. Excellent. Mr. Trinick, when that's being prepared, I don't mind what loop as long as the final document gets to me at the right time. But it would be useful for me to understand where parties are in dispute over wording or whether a condition should or shouldn't be attached.
So what you'll get is several columns with the conditions set out, views of one party, the views of the next, and the final column will be where we appear to be at the time it's sent to you.
Brilliant. Thank you very much. So the requirement for statements of agreement, conditions, and the inquiry and hearing documents for each party will be confirmed in the note of this meeting, which will be out by the 20th of February. I'm going to move on now to item 7. We're looking at oral sessions potentially covering the 2-week period, Tuesday to Friday, on weeks commencing the 15th to 22nd of June 2026. I'm happy to begin the sessions as early as 9 or 9:30 a.m. and finish at 5, with breaks depending on how witnesses are faring. Looking at the oral sessions we've agreed upon, do we think that that's sufficient now, the 8 days? Yes, Mr. Trinick.
Yes, sir, I think it is. We've done some working out based on non-availability of certain witnesses. And that's the case. The following seems to work. Given to start with noise on the 16th for CWP and Walker, and continue if necessary into the 17th for Fairleigh Community Council. We had the community hearing session also on the 17th, because I don't think that noise would go on until after midday. We can then do policy, conditions, and landscape and visual on the 18th and 19th. I think that takes into account everybody's non-availability. And then if we have to have aviation sessions, well, they will have to go into the following week. That way, I think we can do it in 1 week, noting that our Lords and Masters have decreed a bank holiday on the 15th. I know.
Oh, is that the day after the football? Right.
Yeah.
Okay. So let's look, I think the ones we're looking at, neighbouring wind farm, potentially, aviation, are the only ones outstanding. So yes, in terms of CWP's availability in the second week, is there any day there that you wouldn't be able to come to a hearing session if we had one on neighbouring wind farms?
Just the Thursday and Friday that week, our council's not available.
Okay, I'll just pencil that in. So CWP.
We've got council coming to the noise session, so I don't know whether it would be appropriate for the hearing session on neighbouring wind farms to be on the Wednesday the week before, after the noise session. I think that makes more sense.
Yeah, I think what I jotted down from Mr. Trinick was noise with CWP, Mr. Walker being on Tuesday the 16th.
Yeah.
Yeah, so
Wednesday
would be the noise for Fairleigh Community Council and then the community hearing session.
Yeah, but rather than the community session, could we not have the neighbouring wind farm session? We were happy for it to be the week after. It just means those 2 sessions are out of the way for us, with council just coming up 1 week.
Yeah, I'm taking into account that we may not have what we have for week 1 here is fairly guaranteed in terms of us sitting, whereas the second week are what might be not required. So the impacts on vortices and the climate change, carbon calculator to CWP's assets, that's further written submissions first, possibly hearing. And similarly with Glasgow Airport in terms of aviation, that's a possibility, not a guarantee. So I prefer that to be in the second week as well. Okay. So if we pencil in at the minute the 23rd for CWP's neighbouring wind farm concerns, and Glasgow Airport, what's your availability in that second week for aviation inquiry?
If you'd indicated so you wouldn't sit on the Monday.
No, I think based on distance, the 15th is a holiday, the 22nd I think would be better for travel.
Yes, but the only specific reservation we had was either avoiding the Monday morning or the Friday afternoon, because one of our expert would be coming from the South Coast. So if you're looking at Wednesday the 24th, I think that would be clear for the airport.
Okay, and you're looking at 1, possibly 2 witnesses. Mr. Trinick, would you be doubling up on that?
Depends what topics we're left with to discuss, and I don't know that yet. If it's just the IFP we're talking about, a technical issue, one witness. I reserve judgment until I see what comes through from Glasgow Airport.
Okay, does anybody have a difficulty with me penciling the 24th and 25th then as potential for aviation? I don't want to squeeze it into one day in case we need more. Mr. Blaine? Yeah.
That works, yes.
Yeah. Then, Mr. McKinnon, you put up your thumb. Are you planning on being involved in that?
Excuse me for, I've never taken part in a planning application of this status. So I don't know whether I'm involved or not at this stage.
Okay, well, let's go back. Okay, so I appreciate you weren't in the first pre-examination meeting. So there are several processes we can use. We can have no further process. We can have further written submissions. We can have a hearing where we have a discussion around the table, or we can have an inquiry session where witnesses are cross-examined, particularly on a technical or specialist aspect. So for the issues raised by Straven Airfield, at present, we'd agreed to have further written submissions. And from what you told me, you felt that those had come to a close. I was going to review them and check there wasn't any other information I required. But if you wanted to be involved in the sense of drilling down into that evidence further, or you felt that I needed to drill down into that evidence further, then there's the opportunity for a hearing or inquiry in those matters.
All right, thanks, sir, for that explanation. No, I was more thinking if anybody wanted to grill me. So that's maybe I'm being slightly big-headed in that. But I'm quite happy with the written submissions as we have at the moment, but I'm available if other people feel they wish to ask questions and interrogate and delve deeper.
Okay, well, we're not planning for that at the minute, Mr. McKinnon, but you're certainly welcome to observe these inquiry sessions if they do happen. Okay, so I think we've got agreement now, unless there's any disagreement from anyone. 16th, noise involving CWP and Mr. Walker. 17th, noise, Fairley Community Council and the half-day community hearing session. The 18th, policy and legislation and conditions. The 19th, the landscape and visual impact hearing. And then the following week, if required, 23rd, CWP neighbouring wind farm issues. 24th to 25th, aviation inquiry. Mr. Thompson.
Yeah. One thing that concerns me, we moved on very quickly. You mentioned transport, and one of my concerns is the internal circulation of the road system that is proposed. I'd be very interested to get more details of that as to the radius of curvature that the parts would require to move, and how the various watercourses are being either culverted or bridged, the size and width of and depth of the construction, which would affect peaks. And I think one thing that Marcus would thank me for is if on all the water-bound surfaces, they were to use an all-wheel drive tractor. I've been walking these hills quite frequently, and it's been really annoying seeing people struggling to bring in bits and pieces with a normal articulated track, which only has one driven axle, and when it hits a piece of soft ground, comes to a stop. These problems would be easily solved if you were to use an all-wheel drive tractor. With the Army have experience, most contractors have experience, and it would be quite a good health and safety at work thing, as being reasonable and practical as is required by the Act.
Okay, thank you, Mr. Thompson. Again, I'll put that under something that you can liaise with the applicant about. It's not excellent.
Yeah,
okay,
it needs to be something that we're happy that isn't going to cause permanent damage to the hills. And it could we've already had one road washed out this year in West Kilbride with the weather, and it would be rather unfortunate for this to become a frequent occurrence.
Okay, thank you. Well, I'll get you to liaise with the applicant on that, on your interests. From my perspective, I don't feel like there's any need for further procedure. Now, Mr. Finlayson.
Thank you, Mr. Edwards. Can I clarify your comments in respect of the council's participation in the community hearing session? Did I pick that up correctly? Can I also therefore clarify what date that session would be on?
Yep. So we're looking at the afternoon of Wednesday, the 17th of June.
If I could direct you, Mr. Edwards, to the council's email to Hazel Bailey on the 7th of January, we confirmed that that's the last planning committee before summer recess for the council. So it's unlikely that myself and Mr. Davis were able to attend that session on that day.
You're both involved planning committee. There's no one that can delegate or.
Well, I'm the council's chief planning officer, respect, Mr. Edwards, so it's my responsibility to attend planning committee. I can't confirm what items are going to planning committee, but it is the last session planning committee before summer recess. So there is a likelihood, bearing in mind of bringing business to committee before recess, that there will be a planning committee, and if there is, that I would be unavailable to be elsewhere on the 17th of June.
Okay, well, I mean, we could swap, if Mr. Trinick is open to this, the policy session the next day for the community hearing session.
With that, it's really simply one of, I hadn't picked up previously that your expectation was that the council would attend the hearing session. I'm happy that the council does attend the hearing session, but really my clarification was firstly whether I've picked that up correctly, that you expect or wish the council to attend that session. I'm happy to, and my colleague Ian Davis would be happy to also, but it's just to clarify that point.
Yeah, no, I originally had you down to attend. I think because of the way that a community hearing session runs, there might be questions that arise where the council's best placed to answer or confirm something. So what I'm saying as a solution is, what if we swap? So if yourself and or your colleague would be available on Thursday the 18th?
Absolutely. It's just the way this issue.
Okay, so Mr. Trinick, would you be content with that if I swap the community hearing session to Thursday the 18th?
We are, but doesn't that give a problem? Just trying to think. You're taking the policy hearing session into the 17th. That doesn't help the council.
No.
Oh, of course.
It's only the 17th that's the issue for the council. And the difficulty, Mr. Edwards, is it may not be an issue for the council, but I simply can't give you confirmation of that today, and won't be able to until 5 days before the 17th of June.
Okay, well, can we, it'll be difficult depending on how we deal with noise, if it's a hearing or inquiry, but could we swap the 17th for the 16th? Mr. Greenwich.
Dynamic Council, on our information, North Ayrshire Council can't do the 16th either. And yeah.
Well, can we move LVIA? No, we can't move LVIA because the council's not available as well.
Mr. Edwards, we are available, and I've confirmed in my email to Hazel Bailey on the 7th of January that it is only Wednesday, the 17th of June, that the council would be unavailable. My comments were holding the session on the 18th or 19th would be the preference. However, participation on Monday, the 15th or Tuesday, the 16th will be possible. That's simply because we have an agenda and preparation for a committee meeting. But we can be flexible.
Okay, well, hang on, Mr. Trinick. If we moved LVIA to the Tuesday and then shifted everything down one day, so noise with Mr. Walker would be on the 17th, Fairley Community Council and the community hearing session on the 18th, and policy and conditions on the 19th.
We've been informed that the CWP noise expert is not available on the 17th. or 18th, which is why I suggested the 16th.
Right. Well, it looks like the community hearing session. In my experience, the policy hearing session and condition session will not last half a day. There's the policy session maybe a couple of hours and the condition session a quarter of a day. So if I move the community hearing session to the 18th in the afternoon and make sure that we've got plenty of time, would that be agreeable to parties?
So I think that works because not only that, but the landscape and visual hearing session, that won't have the legs to go beyond a day.
Yeah. Okay. Ms. Gould and then Mr. Grosvenor.
Sorry to go backwards. As Mr. Thompson said, we went quickly over traffic and transport. And I think when he was mentioning the road that had been washed out, I presume that the applicant knows that it was the B781 was closed for almost 2 months. And it was closed because of excessive rainfall and a complete collapse in the road. So I wondered whether you've asked for no more procedures on that, but would we be able to discuss the roads and the traffic issues at the community hearing?
Oh, yeah, of course. Well, I mean, we could raise them at the community hearing. It sounds like it's more of a flooding issue than a road issue, though, in the sense of the reasoning for the road collapse. No, Mr. Duckett's shaking his head. I was just wondering if it could be wrapped up within your further written submission.
Well, I think you'd said no more, nothing else was needed on traffic and transport. So
let's add it in. It's perfectly fine to add it into the community hearing session. So let's do that.
I just think there's quite a few concerns about that amongst the community, and the fact that the road that is going to be used by heavy traffic to access the site or proposed is the B781, which I think it was the roads department said that the road had collapsed due to excess rainfall. Yeah.
We'll do that. Yeah, I've noted that down. That's precisely what community hearing session can look at. So that's fine.
Thank you. Thanks very much.
Mr. Grosvenor.
Yeah, I just wanted to clarify the noise session because are we still Fairlie Community Council in the morning of the 17th of June?
Yes, we've got the day. If necessary.
All day, did you say? Because I thought we were going to have the community session in the afternoon on the 17th.
Yeah, no, the community session is now moving to the 18th.
So that means that the 17th will be Fairlie Community Council noise, because I don't understand why you've also got the 16th for noise with community wind power. Would it take that long? Have you allocated a day for that?
Yes, I mean, I haven't seen the additional information as yet, so I would rather. I mean, these will flow, Mr. Grosvenor. So as far as I can see, if it's a hearing, we're probably looking at 1 day.
Yeah.
If it's an inquiry, it could be 2.
Okay.
But I would assume that you would yourself and Fairlie Community Council would be present on both days because of the overlap, which you've already explained. So you may have questions for CWP and the applicant's witness, and equally they might have questions for yourself. So I'm looking at them as being one, but looking at the witness, applicant and council on the 16th and Fairlie Community Council on the 17th.
Yeah, no, that's fine. Thank you for that clarification.
Okay, fantastic. Okay. Thank you. That's great. I think we've got a plan now, and I'll put that in the note of this meeting. We previously agreed to hold the oral sessions in person based on the number of participants and for efficiency. Local community halls are being investigated at the moment for these sessions, and we're looking at the availability of being able to keep material overnight in those locations. Is that still agreed by everybody to have in-person sessions? Yes, brilliant. I should note that those in-person sessions, sorry, Ms. Holmes.
Just really to clarify whether if we have somebody speaking for our proposals and topic who's abroad, are you able to use online services as part of it?
Do you mean, can you access the internet on Wi-Fi? That we'd be looking at halls that have access to Wi-Fi?
Yes.
Yes.
Okay, that's fine.
Yeah, I mean, I wouldn't want you scouring the internet or or using AI or something to to think about questions. It'd be more of a use of all of us will be using some form of technology to look at documents. I, for example, will probably have a couple of screens in front of me.
Sorry, I didn't make myself clear. No, it was only if we were proposing to have an expert speak, but they're abroad at the time of this meeting.
Well, they're abroad. Yes, of course. I'll investigate that, but we'll have to make sure that we've got sufficient Wi-Fi strength to allow that to occur. But yes, I'll have a look at that.
Thank you.
Okay, on that point, because some of you may or may not be aware, there are other competing projects that require reporter time and are being broadcast through live webcasting in June. And as a consequence, it may not be possible for us to record or live broadcast this particular inquiry, but there will be microphones and myself available, just to make you all aware of that at present. Sorry, Miss Holmes, your thumb's still up, your hand's still up.
Sorry.
Nope, okay. Excellent. Okay. Any questions about the dates, the location, or the duration? No? Okay. If you see in Annex B of the agenda, there's a draft timeline for the inquiry process. I'll confirm that timeline within the note of this meeting. Obviously, we've adjusted it for outline hearing statements. Otherwise, are parties content? Yeah, fantastic. A foundation document list with hyperlinks to documents was issued on the 9th of December 2025 and is available on our website. This is to be used and referred to by all parties participating. I'm going to ask the applicant to liaise with parties again in case there needs to be any update to that foundation list, with a final foundation list to be produced by the 13th of April. Is that okay, Mr. Trinick? Yes. All supporting document statements should be submitted to DPA by email and in a Word format, or in some instances, if it's too large, you can use our case management system. Once all documents are submitted, the applicant will finalise the full document list prior to the oral sessions. Please note that every party has a unique prefix that should be used for supporting documents, and I'll put that within the note of the meeting so you're all aware of what that prefix is. Are parties content with that approach? Yeah, super. So in terms of site inspections, as previously expressed, I'll undertake unaccompanied site inspections prior to the oral sessions in June. In general, I'll visit the representative viewpoints contained in the environmental report and the residential visual amenity assessment. Parties have also indicated to me other locations to visit, including houses at Monagh. Are there any other locations that anyone would like me to visit? No, Mr. Thompson, yeah.
As I say, I've sent you a list as you requested, going from site A to site T. No. Yeah. So I'd like, if you can confirm that in the course of your visit, you visited all of these. I've been mostly.
Yes. Yeah, I will do that. And if I have any difficulty visiting any of them, I'll also make parties aware.
Yeah. And as I say, if you need guidance, I'm quite happy to meet you and anybody from one of the applicant's engineers or something on site.
Okay, thank you, Mr. Thompson. Now, parties are encouraged to abide by timescales for submissions. Unsolicited correspondence and late submissions will only be considered if there are justified and exceptional circumstances to be accepted. Is that noted by parties? Brilliant. While previously we agreed, that summaries of case and closing submissions would be invited in writing for the oral sessions. Generally, objecting parties will be given 14 days after the last session to provide their submissions, with the applicant given a further 14 days to provide its submissions. Is that still agreed? Yes, fantastic. Okay. Should you have any questions, please contact Hazel Bailey at the Directorate. Her details are on the PEM agenda, but will also be included in the note of this meeting. I'll issue the note of this meeting by Friday, the 20th of February. And within 14 days of receiving that note, you must inform DPA if any of the procedures that you wish to participate in. Is that noted? Brilliant. Are there any other matters that anybody would like to raise? No. In that case, thank you very much today. That was just over 2 hours, so I appreciate your time. And I'll look forward to seeing you in due course. So thank you for your time today.